Happy Friday Night Live, everybody! I was getting my earrings on and I dropped the back of one of them and it was a whole situation. Happy Friday! It's a very special stream because tonight we are celebrating my birthday and we're celebrating 100K and we are debuting the very purple hair. Yes, it is not a filter. Yes, it is my purple hair. Yes, my hair is purple. I'm so excited to be here. What you guys will see first is that tonight is a fundraising stream for RAINN. If you're looking for more information, the link is in the description and it's under the fundraising portion. This fundraiser is through YouTube, so they do not take 30%. They donate it directly to the charity. So anything super chatted tonight, I'm going to make sure we get through super chat questions. Anything super chatted tonight will go directly to RAINN. I know sometimes, especially during COVID, it can be hard to feel like you can make impact and do good. There has been a lot of struggle over the last year, but what I found when we did the fundraiser for Nashville after the bombing was that, you know, little by little, a little becomes a lot. And we did that together and it was a really powerful thing. So I thought, what better way than to do a charity stream for my birthday? You guys have always been so generous with super chats and I wanted to make sure that that was going to a good cause. Since we had talked so much about things in the SA realm with the cases from James Charles to, the stuff with Josh Duggar to what we've covered with David Dobrik. It has had a lot of very sensitive and very heavy topics. So I figured one of the things we could do to help and to at least feel like we're doing something is to add a charity stream to this. The Paw Nerds have learned how to open the barn door to my office. So they will be in here as they desire to be. They're 5 months old. They have discovered that if they lean against the barn door, that they can. I share very openly that I am ADHD. So it can be challenging sometimes when they are in the office playing with things. I will do my best. So if you see me looking away, it's because the cats are playing. Trudy, my love, it's so good to see you. Thank you, friend. I don't have any idea what time it is in New Zealand, but I am glad you are here. It's so good to see everyone in stream. And again, a huge thank you to our mods. They have dealt with really heavy topics, and those streams can be hard on everybody. So tonight, we're going to talk about hair. We're going to get to a Q&A, but first we're going to talk about the Triller H3H3 lawsuit. We're going to do one quick breakdown, and then we are going to bump into fun stuff and do a Q&A on kind of anything. Law, my life, the purple hair, all the things. So that's the plan. Peter Mon, it is so good to see you, friend. Thank you for all of your support. I hope you are well. It's great to see creators in here. I know the chat is going to lose their minds that they're in here. You guys, if you want to chat at Peter, go right ahead and chat it up with Peter in the live chat, please, by all means. So, y'all, what do we think of the hair? What do we think of the hair? Give some purple hearts if you're loving it in the chat. I feel like the purple hearts are going to become the cry of our people. We use the scales of justice a lot, but I feel like the purple hearts are now coming in as one of those law nerd moments. I don't know why my stream was doubled up for a second. So the purple hearts are definitely becoming one of the law nerd moments. Where did my stream go? I had lost my front end of the stream. That was interesting for a second there, but as long as y'all have me and we get to see purple hearts, and then we're going to get into it. So as those come in, and because it's a birthday stream, I brought something fun. We're going to open it on camera. This could be a disaster, but I brought a towel. So we are bringing a Paloma Rosa. Look, it is sparkly AF. I'm very excited to open this up and give it a whirl. So it's on ice. It's a whole thing. I love seeing all these purple hearts. Thank you guys. You are ready. Let's just get into it. It is time. It is time. It is time. It is time. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. You guys, it's a fun night. Thank you for all the purple hearts. I love it. I love that we threw in a blue heart there for the Peter Mond. He uses blue hearts on his channel, and I love it. It's so good to see. The cats are just going to be loud. They're playing with bags. I am not even going to get to all of these. Thank you, thank you, thank you, thank you, thank you. It's a very purple. It's like a purple palace over here today. Fred, calm yourself. Cat, calm yourself. He is just jumping in and out of bags. Thank you. I'm very, very, very excited about this purple hair. I'm going to share all of the information. Thank you, Allie. I love it too. I'm going to share the information from my wonderful hairstylist, Garland. And if you guys are local, let me know. I will share that. I'm going to share his Instagram over on my Instagram, and that's going to be a blast. So he used, Pulp Riot color, and I'm so excited. I couldn't be more excited. So this is what we're doing. It's a combo of 3 different purples. When it was like, how purple do we want it? It's like full ass purple, like vibrant ultraviolet purple. Do you know what he said to me at the end? After we were done, I'm like, I can't wait. We're going to have to try like galaxy hair and other hair. I'm ready to explore the world of vibrantly colored hair. He's like, so have you ever considered oil slick hair? And I'm like, actually, the law nerds said that oil slick hair should be a conversation, seeing that I have a hollow obsession. So we're on the same page. We're on the same page. So eventually there will be oil slick hair. Spill Sesh, thank you so much. I appreciate it. I appreciate all the shout outs in your videos. I've been really enjoying watching your coverage of the James Charles employment lawsuit. What I love, you guys, about the commentary channels, like Truth Sleuth Alley, like Spill Sesh, like Peter Mon, like Dustin and Nick, and like Adam McIntyre and others, is that they pull together all the context in the pop culture world. So they pull together the context and the clips from social and what's been said on Twitter and bring that context to the lawsuits. I don't often have that context. With Toddy Westbrook, I did just because I had watched it all go down. But even then, that's how I found the commentary community, because I was like, I don't understand all of this. So I love bringing the context to it. And that's the same thing I love about like Bea Lucille and Aphrodite, is seeing the context around all of these different situations. And tonight's context is going to be H3H3. I'm sure a lot of you watched the H3H3 podcast today, where they touched briefly on the lawsuit. It was a 3-hour stream. I love a long stream, but I only watched the first part where they talked about the suit briefly. I love the way that Ethan addressed it. I will talk about that and kind of give thought about that after we break down the text of the lawsuit. Right now, we're going to pop champagne after that, because I want to make sure that I don't pop champs until we move into celebration, because I don't want to muddle my words truthfully while we're talking about this lawsuit, because I have feelings about it, and I'm trying to be respectful with this lawsuit. So don't worry about it. We're going to break it down. There's a lot of context. Allie, thank you so much for updating everybody about what we raised. I set the big goal of 5,000. I left the fundraiser open so that the replay crew, we love you, that the replay crew can participate too, because that was one of the hard things from the last fundraiser, is that the replay crew was like, wah, like we weren't live because of time zones, life, and what have you. So I figured it out through the back end of YouTube, because they've got a whole giving section on how to do it, which I didn't know last time. So able to leave it open, which I really love, because then people who come across this video after it's live can also support if that's what they want to do. So yay birthday stream. Thank you for supporting the fundraiser, and thank you for supporting RAINN. And I know that it binged. Holy shit. We're at 106,000. Oh, it binged. Move your head. Ah! How is it going? How is it still going, you guys? We hit 100K literally on Monday. Google doesn't even recognize me as a 100K channel yet, but y'all have kept going, and we're now at 106,000. It binged. If you're new here, go ahead and subscribe. We don't always do celebrations, but when we do them with purple hair and fun. All right, let's talk H3H3, and then let's just fuck around and have a good time. So, not that this isn't going to be a good time. This is going to be a good time because this lawsuit is quirky. And guess what y'all know a lot about? Y'all know a lot about jurisdiction. And we're going to play along with spot the jurisdictional issues because man, oh man, we've got them. There are over 2,600 law nerds in here. Y'all, did you watch the Duggar stream? We almost hit 11,000 law nerds on the Duggar. It was a big deal to me, Fred. We almost hit 11,000 concurrent viewers on the stream on Wednesday night. It's just crazy. Hello, El Jefe Reviews. It's good to see you in the channel. Okay, let's talk H3H3, and we're going to timestamp it, and then I will come back to the chat because otherwise I'm excited tonight. I'm hyper. It is birthday. So I don't want to get distracted. So if people just want to hear about this lawsuit, they don't have to deal with me jumping all over the place. Y'all have been through a 1L course in jurisdiction. So let's just jump. Oh, I was muted. I'm sorry. As I'm talking on and on, I told you I was excited. See, I'm trying not to drink in everybody's ear. This is what happens when I'm excited. We're gonna start this again so we don't timestamp me being muted. Triller versus H3H3. Triller is a fight club that aired the Jake Paul fight against Askren. I don't know if it was a fight or if it was a concert where Jake Paul punched a dude in the face and that dude fell down, and then they called the fight. It was very odd. It was an odd fight. And my husband and I enjoy UFC. Our youngest is actually named after Forrest Griffin because we are fans. And yes, we name our children after people we stan. We're those people. I tried to name my oldest David Matthew Baker. My husband absolutely put his foot down on that, but I absolutely tried it. So anyway, we enjoy fights. We've been to live fights. I like a fight. This was not a fight that I enjoyed seeing at all. Not a huge fan of Jake Paul, not a huge fan of his content. Gonna just make that perfectly clear as we go through this. It's my understanding that Jake Paul is in fact a investor into Triller Fight Club who hosted the fight and who promoted the fight and aired the fight. This was a pay-per-view fight. So this is a pay-per-view fight that again streamed on pay-per-view. It was what, $50 or something. They are suing a whole bunch of people for a whole bunch of things. Let's just jump forward. filmdaily.com, accesstvpro.co, online2livestream.us, crackstreamslive.com, sportstoday.com, mysportsclub.com, billasport.com, trendy clips, a dude named Mike. No, they just called him Mike. Some dude named Mike. Your Extra. Why, thank you. I live by the motto, be too much. Thank you, Peterman. Xslipped Gaming. It's Lil Brandon, H3 Podcast, and H3H3 Productions. So that's who's being sued. We're going to talk about that in a minute. They are being sued for copyright infringement, violation of Federal Communications Act, violation of the Federal Communications Act under this other section, conversion, which means taking one person's shit and then taking someone's shit and then converting it to your own, breach of contract, conspiracy, violations of the Computer Fraud and Abuse Act, vicarious copyright infringement. Oh, y'all. So let's get into this. I don't know any of these defendants. I'm curious about who Mike is, but this has links to all of their YouTube channels, so we're absolutely going to go check them out and see. This just talks about who Triller is. Triller Fight Club is a Delaware limited liability company. Doing business, by the way, in California, that's going to come up. This is a lawsuit in federal court in the Central District of California. So diversity jurisdiction is generally what we're going to be looking for here. So we'll see how diverse these parties are as we get into it. Nature of this action. Let's just... Through this action, Triller seeks in excess of $100 million against defendants, and each of them, all of whom are cyber criminals, for their outright theft and diversion of upwards of 2 million unique viewers by providing them with illegal and unauthorized viewings of the broadcast of the Jake Paul Ben Askren boxing event? Question mark? Question mark? Question mark? Plaintiff is the copyright owner and publisher of the Triller Fight Club broadcast of Jake Paul Ben Askren. I agree that that is true. I agree that that is accurate, including all undercard bouts and the entire television broadcast. I agree that that is accurate. Exhibited via closed circuit television via encrypted satellite signal. Right. It was a pay-per-view. The broadcast originated via satellite uplink. Great. Tech. It was a pay-per-view. Plaintiff institutes this action to obtain a remedy for and to permanently hinder the blatant, unlawful infringement and rampant theft of its copyrighted work by defendants. I am going to make a side note. This is the first amended complaint because originally H3 wasn't added, and originally they had included some conspiracy charges, more than just this one. It'll be very interesting to see how these particular defendants conspired together. I have so many questions. I have questions. Defendants in each of them have utilized various torrent and streaming websites. Yes, again, torrent websites being used for allegedly illegal shit. Shocking. Such as YouTube, filmdaily.co, accesstv pro.co, online to livestream US, crackstream live, sports-today.club, my sports club, and Billa Sports. So these are some of the defendants. YouTube is not a defendant. YouTubers are defendants. And they use those sites to unlawfully upload, distribute, and publicly display without authorization the broadcast to the users of such websites upon information and belief. Defendants in each of them acted knowingly, willfully, unlawfully, and with blatant disregard to plaintiff's copyright in the broadcast by uploading the broadcast to the aforementioned websites with additional shareable payment links. Herein is part of the rub, such as PayPal links, which allow users to remit direct payments to the various defendants in order to fund and endorse each respective defendant's infringement of plaintiff's broadcast. I don't know how that comes up with H3, but okay. Defendants' calculated and reprehensible infringement, theft, and other unlawful acts. I said hacks. I meant acts committed in knowing violation of the law has resulted in damages suffered by plaintiff in excess of $100 million by stealing and diverting upwards of 2 million unique viewers of the illegal and unauthorized viewings of the broadcast from plaintiff. I think they're just pulling the podcast views from H3H3 and going, see, these people would have watched the fight, but they didn't. They watched H3H3 instead. No. H3H3 talked about it after the fight, but okay. It was after it happened. It was after. So it can't divert it if it happened after. I have questions as to how they got to this 2 million unique viewers number. I have lots of questions, but I'm loving the language reprehensible is sending me, so let's keep going. Acting with intentional and knowing disregard of plaintiff's exclusive rights in the broadcast. Okay, I agree with that too. No, not the knowing well, yeah, they would know it was a pay-per-view. Everybody knows it was a pay-per-view. So everyone knows it's a pay-per-view. Defendants who are nothing less than cyber criminals. Let's chill for a second on the cyber crime. Like, okay, It's a podcast that made fun of your fight because the fight sucked and the performances sucked, and even the commentators like Pete Davidson just hated Jake Paul. So the fight was not a good fight. Why you mad, bro? The cyber criminals are sending me, especially in a week where we have talked about actual horrendous and reprehensible cybercrimes. We have talked reprehensible cybercrimes this week. Guess what? This ain't it. This ain't it. This ain't it. But let's keep going with the other lawsuits we've talked about this week in mind. Well, the criminal actions. Defendants who are nothing less than cyber criminals. I need Ethan Klein to make a shirt. Teddy Fresh, please make nothing less than cyber criminals merch, because that would be fucking glorious. Can you imagine Nothing Less Than Cyber Criminals by Teddy Fresh? Name it lawsuit, pull a mischief, say mischief managed, and sell that shit and fund the lawsuit through the sale of the shirt that says nothing less than cyber criminals. Please. And then use this to fight the lawsuit on fair use grounds. I live. I would be living. Okay. I'm going to stop. No, I'm not going to stop laughing. We're going to have fun with this. I mean, we're just going to have a good time with this. Defendants who are nothing less than cyber criminals employ various user profiles on websites, including those mentioned above, to illegally upload copyrighted programming. We'll talk about this with regard to H3 in a minute. Including the broadcast, and to facilitate the unauthorized copying, sharing, downloading, uploading, and distribution of such programming. Look, that shit you can't do. True. Refer back to our conversation about torrent sites, LimeWire, and Napster. Through their egregious conduct, we've gone from reprehensible infringement to egregious conduct. I'm loving the words. I'm loving the words in here. Defendants also encourage other online users to copy, share, download, distribute, and share the broadcast on the aforementioned websites. Defendants further unlawfully facilitate, participate, and induce other users to engage in the unauthorized reproduction, adaptation, distribution, and public display of the copyrighted broadcast. Yes, sue all of Twitter, because all of Twitter had clips of it. So sue Twitter, not the company, the people on the Twitters. And publicly display the plaintiff's copyrighted broadcast, all to line their own pockets with monies that belong to plaintiff. Angry, bro. Angry. Notwithstanding each defendant's recognition that plaintiff never authorized their respective copying, downloading, uploading, public display, and or distribution of the broadcast, defendants continue to engage and unjustly benefit from their infringing conduct. How do they continue to benefit? I'm curious. Maybe because you sued them and now everybody wants to see what they did. Defendants' plain acts of thievery, misappropriation, and infringement, as further described herein, are tantamount to and no less deplorable than the acts of a pilferer, poaching on or looting. Come on, you wrecked the flow of this sentence at the end here. Poaching on or looting the fruits of another's hard-earned labor. There was no labor in that fight. I watched it. No one labored in that fight. No one. There was no labor at all. We're going to do that one more time because this sentence is sending me. Defendants' plain acts of thievery, misappropriation, and infringement, as further described herein, are tantamount to and no less deplorable than the acts of a pilferer looting the fruits of another's hard-earned labor. There, I fixed it for you. This lawsuit. Look, we are going with at least a 7 for entertainment in the writing of this complaint. So when we come to be consumed on social media entertainment factor, I am entertained. And I feel like there's a lawyer somewhere going, "Are you not entertained?" I'm more entertained by the writing of this lawsuit than I was by the Jake Paul fight. I'm going to be honest. We've used the word pilferer. We've said egregious. We've said tantamount, which is always fun to say, and reprehensible. So I'm more entertained by the lawsuit so far than I was by the fight. This is the truth. This is the way. All right, jurisdiction and venue. These sad little paragraphs are not going to survive. Y'all, what are... This court has subject matter jurisdiction pursuant to 17 U.S.C. 101, which states that district courts shall have original jurisdiction in all civil actions arising under the Constitution. Okay. Upon information and belief, venue is proper in this court because a substantial part of the events or omissions giving rise to these claims occurred in this district. In the alternative, venue is also proper under 28 U.S.C. as defendants in each of them are subject to the court's personal jurisdiction with respect. Well, only some of them are. Not all of them are. Not all of them are California parties. So you've got these weird mixed jurisdiction because not all these companies are California companies. So how are you going to bring in the non-California companies is my question. And these parties are all joined weird. Like they all did different shit. So it's strange to me that we're trying to join them all in one lawsuit when it's going, like the use is going to be different to each one. So I think we potentially have some jurisdiction issue. I think we have some joinder issues, but so does the court. And we will get to the court's response to this in a minute. Plaintiff is a limited liability company incorporated and having its principal under the laws of Delaware, having its principal place of business in California. Great. They do pay-per-view fights. Great. Defendant Film Daily is a Nevada company doing business in California. Defendant Access TV Pro is registered in California. They think they're doing business in the state of California. We will see. Defendant Online to Livestream US is doing business in the state of California. I want to know how they're going to prove all of these companies are doing business in the state of California. Is it because they're streaming or are they all actually in California? I do not think so. Crack Stream Live. What do they normally stream? Should we click it? If I get a computer virus, I'm going to be pissed. All right. Well, we're going to click it anyway. What does Crack Stream Live? This looks like a bad idea. Yeah, we're not doing that. Let's see. Where are you located? Do you say where you're located? Where's jurisdiction for your website? Why doesn't it say? You're supposed to have a jurisdictional statement on your website and your privacy policy. Where is it? Normally at the bottom. I don't see it. Last updated May 29th, 2014. I am very curious how they are determining that this website from Crackstream Live operates out of California. Their statement down here is updated, copyright 2021. I'd be very interested if some of these companies aren't offshore, but I'm just saying we're gonna have some jurisdictional issues with some of these companies. Upon information and belief, defendants Sports Today Club is doing business in the state of California. I bet we're going to see answers from these companies going, yeah, I don't do business out of the state of California. So suck it, friends. Defendant My Sport Club is a business entity, the exact nature of which is unknown. We just think you're in California. Fantastic. Defendant Billasport is in California, they say. Defendant Trendy Clips is a YouTube channel that they say is operating out of the state of California. Now, do they really? Or, look, this channel has no content. They have 42,000 subscribers, and their profile picture is Jake Paul and Ben Askren. Touche, Trendy Clips, but you have no content. Do you think it's because of this lawsuit? I mean, I guess that's possible. Because it's like, okay, come find me. How are you saying I'm doing business in California? Is it because YouTube's in California? Because if the person who's putting the uploads up isn't in California, we've got problems. Defendant Mike. Mike. Sorry. I love that commercial. Hump day. Let's see who Mike is. Hi, Mike. Mike. Oh, it's not just Mike. It's Mike Boxing, y'all. See, look, let's go to the about. Subscribe for Mike. Just a pro tip here. You could do a little bit more in the description here, friend. Joined July 11th, 2020. Fairly new channel. Good number of views. You go, Mike. I wonder if these views are all coming from the fight. So Jake Paul, Ben Askren, Full Fight Boxing HD. Well, that one sure is uploaded with 876,000 views. All right, well, that one's there. So there we go, Mike Boxing. That's a re-upload. There we go. Mike is a re-upload. Your Extra. Let's see what Your Extra does in this. I don't know how they're saying they're in California. Oh, that's Mike again. Interesting, because that seems that. I wonder if the lawyer cut and paste wrong, because this is the same link. I bet they did. Somebody made a cut and paste error. We're not going to go track down Your Extra. Oh, did they do it on all of them? Dependents XSplit Gaming. Yep. Somebody needed to double check the links. You always double check the links. Double check the links. Defendant, it's Little Brandon. Guess what? Same link. Unless Mike owns all of these YouTube channels. Check the links. Look, I put up a broken link yesterday. I felt like an idiot. I was like, damn it. Broken link. Oh, look. Did they get H3's link right? Oh, yes. It looks like they did. This is the H3 podcast. Their link's correct. Fantastic. Let's see. Did they get the other one right? Oh, and what they say about H3 is that they are doing business in the state of California. Their hosts are Ethan and Gila Klein. We know this. They operate the YouTube channel located at for the purposes of permitting, encouraging, facilitating, and inducing the sharing of videos and live programming of audiovisual materials between users of the website. How? Okay, sure. These materials include programming owned and or controlled by plaintiff, including the broadcast, which was offered by the H3 podcast through its illegal uploading and distribution of the broadcast. From my understanding, they uploaded a clip of it to share a very short clip on their podcast, but they're going to argue fair use on that. But it was uploaded because we saw that on a link. When they showed the short little clip of it, Ethan Klein was talking about it tonight. Upon information and belief, defendant H3H3 is a business entity. Is it separate than the podcast? Did we do a basic business search? I have so many questions because they're saying it's the H3H3 Productions site. I don't even know this site. It looks like I don't watch the productions side of things. I don't know. Did they put the video up here? These are from like 9 months ago. How is this particular the last videos from 9 months ago? How is that? They all seem to be about Keemstar. Like, how is this? What? Okay, sure. Go ahead and say that website's part of that particular YouTube channel is part of it. Cool. Plaintiff is informed and believes and thereon alleges that the actions and omissions that serve as the basis for this complaint were undertaken jointly and with the consent, conspiracy, cooperation, and joint participation of all defendants. If there was ever a stretch or a reach of the lawsuit, if there was ever a reach is to say that these all of these websites and YouTube channels undertook this jointly with the cooperation and joint participation of the others to do this. How are you going to prove that? I have so many questions about where this grand conspiracy comes from, because this is a problem. Plaintiff is informed and believes and thereon alleges that at all times, each defendant was the agent, joint venture, and or employee of each and every other defendant. Bruh, what are you doing? Is Mike the agent of H3H3? Is Mike in what? How? This is going to kill this conspiracy stuff is going to kill their lawsuit. And in my opinion, and I think that the reason they did this is to join all these defendants. Here's the thing though, it's not a class action lawsuit. So to join these defendants, you would actually have to have a reason to join them all into one lawsuit, not just because each person pirated it. You should sue each one individually. They might get this kicked on joinder at the beginning. This might not get off the ground. Count 1, copyright infringement against all defendants. They reallege all the shit above. Plaintiff owns the stuff. This is the thing I agree with the most. Plaintiff owns the rights. I'm not going to argue with them. Copyright infringement is a problem. I'm not going to argue with them on that. But you have to go about it properly because process matters. Defendants in each of them failed to obtain the property. What? This was hard the first time I read it and highlighted it. Defendants and each of them failed to obtain the property, authority, I think we mean proper, or license from plaintiff to copy, publicly perform, or distribute the broadcast. Okay, fair, but also, upon information and beliefs, defendants illegally copied, uploaded, publicly performed. And then Jake went like this. And then Ben went like this. The broadcast via the internet with full knowledge that the broadcast could only be obtained by purchasing a license from plaintiff. Defendants in each of them utilized various torrent streaming websites, such as everything, including YouTube. Specifically and upon belief, each of them obtained broadcasts through internet websites, cable, or pay-per-view. The pay-per-view purchases, this again is true. The pay-per-view purchases are private, non-commercial viewing and subsequently illegally retransmitted the broadcast and publicly exhibited the broadcast by illegally copying and uploading. So the copying and uploading can be a problem, but I don't know if they're even going to get that far. Again, $100 million. I mean, okay. Count 2, violations of the Federal Communications Act. The broadcast was available for non-commercial private viewing through plaintiff, its authorized online vendors, and through pay-per-view. They accessed it without doing that. Therefore, they shouldn't have done that. It's like you can't commercially re-air the Super Bowl without having a license to re-air it. So there are, like, with regard to the re-airing and redistributing, I get it. But also, we're not going to get that far. I want to know how all the plaintiffs how all the defendants are working together. Upon information and belief, plaintiffs allege that defendants effected unauthorized interception and receipt of the broadcast via defendant satellite TV services by ordering programming for residential use and then copying. So you bought it and then you just replayed it so nobody else had to buy it because it was a terrible fight. By reason of defendant's conduct, as described herein, defendants and each of them willfully violated 47 U.S.C. 605. As a proximate result, pay us $110,000 for each violation. It will be interesting to me if they try to argue the violation is the upload or the violation is the view. The violation is generally going to be the upload. All right. Count 3, violations of the Federal Communications Act under 533. It prohibits the unauthorized receipt of any communication service offered by a cable system, such as a transmission of the broadcast which plaintiffs own. So this is receiving the illegal pay-per-view. Upon information and beliefs, defendants knowingly, willfully, unlawfully accessed, received, and subsequently retransmitted the broadcast when it was offered via cable TV or internet subscription without the authorization from plaintiff. The thing is, H3H3 is going to be like, we only used a clip and it was fair use for newsworthiness and reporting. And what's interesting about that, and H3 talks about this, and if you guys are interested, I will break it down. H3H3 has one of the few fair use cases that has like gone all the way through court. So at some point, H3 is going to rely on the precedent from their case that they set because they fought it years ago to defend them. In this case, they're like, oh, we've just, thank you, past us. And they're going to be like, yes, future you can rely on what we've done here, the groundwork we have laid. And that is going to be very interesting. It's like when lawyers get to cite themselves. It's like, per this case that I've already done with this law I've already created, Count 4 for conversion against all defendants. All the stuff above, virtue of their conduct, they unlawfully converted it for their own commercial use. For that, they're going to have to show financial gain from the rebroadcasting. They're alleging up there that some of them had PayPal links and stuff. We'll see. It'll be interesting if they try to make the argument that because it was on a monetized YouTube channel, that little clip was the conversion. But again, the defense will be fair use. And again, fair use is a defense to copyright infringement, but you can still be sued for copyright infringement. You still have to then defend yourself as to fair use. For breach of contract. What contract? So breach of contract is, they're saying to all defendants, but if the defendant pirated it, if the defendant didn't pay for the pay-per-view, there was no contract to breach. If the defendant paid for the pay-per-view and then re-uploaded it, then there's an adhesion contract in that. But if the person pirated it, there's no breach of contract because there's no contract. It's a separate section. So that's going to be interesting. Defendants and each of them purchased the broadcast through plaintiffs' authorized websites for residential viewing and then re-uploaded them. Well, that's not going to apply to anyone that didn't pay for it. So there's that. Also, yay. Thank you, Allie. Again, the amount proven at trial will be no less than $100 million. Yes, I'm channeling my inner Bruce Bufford. Count 6, conspiracy against all defendants. Tell me where the conspiracy is. Where is the conspiracy? The defendants set out to intentionally, willfully, and unlawfully access. Well, if they unlawfully accessed the broadcast, then they didn't breach the contract because they didn't buy it. Which is it? Did they unlawfully access it? Or did they breach the contract by buying it for personal use and re-uploading it for commercial use? Which one? You cannot have both. You cannot have both. Upon information and belief, pursuant to the respective defendants' agreements, defendants set out to intentionally who agreed? And unlawfully access and copy the broadcast and subsequently upload the broadcast for distribution and public display on the websites. Look, they have not alleged any substantial act. I mean, I don't even know if that count would survive a 12b6. I don't know if this is actually pled well enough, and the standards are low. I don't know if this is actually pled well enough to not just get bounced. No, look, lawyers, there is not much here. This is thin. This is very, very thin. There's just no facts here. So I don't know how count 6 is ever going to survive. And if count 6 can't survive, this can't all be one lawsuit. You have to go sue each of these individuals individually. And they don't want to do that because it's fucking expensive to go sue all these people on their own. But you can't just improperly join them and say it's a grand conspiracy and have it be fine. How are you going to prove that Ethan Klein talked to Mike? Mike. Do you think that's what happened? Ethan Klein was like, Mike. Where can I get the stream? Because I don't think that happened. I just don't. Thin. This is thin. Violations of Computer Fraud and Abuse Act. How? Let's see. I'm dying to know. It is on information and belief as a proximate result of defendant's unlawful and fraudulent conduct as set forth herein. They obtained the valuable copyrighted broadcast, the most valuable ever, and subsequently uploading, distributing, and publicly displaying the broadcast using such. That doesn't even make sense. That sentence makes no sense. There's not a lot alleged here either. How? Okay. Once we've gotten past, we've jumped the shark here past count 6. Count 8. Various copyright infringement vicarious. Sorry, we had our dyslexic moment. For all of you that are new here, I am actually diagnosed dyslexic. So when I say I've had a moment, it's because I've actually read something wrong and had a moment. It is not me trying to be cheeky. Plaintiff is the owner of the copyrights of the broadcast. Yes. Defendants and each of them directly infringed on plaintiff's broadcast by illegally uploading the broadcast and or portions. That's the first time they've included portions thereof via the internet on various websites. Upon information and belief, defendants encouraged online users to copy, share, download, distribute, and share content, including the broadcast. It'll be interesting to see what they have about that. Because did Ethan Klein tell people don't pay for this? Like, just watch it here? Because I don't think he streamed it until after the fight was over. And after the fight was over, I don't know if they can claim harm because you can't buy the pay-per-view after the fight's over, on my understanding. Defendants had the right and ability to control and prevent the users on such aforementioned websites from directly accessing and infringing on plaintiff's broadcast, which was copied, uploaded, and distributed by defendants in each of them. Defendants derived a financial benefit from users' activities. Again, if it's after the fact, there might be some issues there. Due to defendants' act of copyright infringement alleged herein, defendants have obtained direct and indirect profits that defendants, I'm adding words, direct and indirect profits defendants would not otherwise have realized, but for defendants' infringement of the broadcast as such, plaintiff is entitled to disengorge. One of my favorite words. Plaintiff's entitled to disengorgement of defendants' profits directly and indirectly attributable to defendants' infringement, an amount to be established at trial, but no less than $100 million. Prayer for relief. Oy. As to count 1, that defendants and everybody not do it again. Okay. That plaintiffs be awarded profits from defendants plus all losses to plaintiff, the exact sum to be proven at trial, in no event less than $100 million. Sure, bro. That an order be issued requiring defendants and each of them to account to plaintiff for profits attributable to their use of plaintiff's copyright in accordance with proof. Actually fair. I mean, hey, how much did you earn off of this stream? Hey, Mike. Is this monetized? If this is monetized, then maybe. But if this is not monetized, then what? Then what? Count 2, statutory penalties in the discretion of this court, up to a maximum amount of $110,000 for each of defendants' willful violations. That would be each upload. For damages within this court's jurisdiction and the amount according to proof of trial, no less than 100. We get it. Punitive damages in an amount appropriate to punish defendants and deter others from engaging in similar misconduct. For damages within this court's jurisdiction and an amount according to proof of trial, no less than, okay. And consequential damages, okay. All right, count 6. We get it, $100 million and punitive damages to punish the defendants. As to count 7 for damages up to, injunctive relief enjoining from copying, uploading, distributing, selling, or otherwise infringing on plaintiff's copyright in the broadcast. Injunctive relief would be like, Mike, take it down. However, can't they just copyright strike this and YouTube pull it down? Like, have they not done a copyright strike on the channel? Like, what? Just copyright strike the channel. It'll come down. But no, we want to sue Mike. Wait, this is not the right. There we go. We want to sue Mike. We want Mike to be sued. As to count 8, enjoined from doing it again, $100 million. An order be issued requiring defendants to account. The accounting makes sense if they re-uploaded it. So far, we've seen one channel linked that re-uploaded it. And then for prejudgment and post-judgment interests, filed April 29th by Norvin and Norvin LLP. So that is the first amended complaint. Oh my googly goodness. We're going to look at the court's response. This court response was to the first complaint, but I didn't see anything substantially changed in the second complaint. So. All right, let's pull up what the court had to say of its own motion. This was a minute order issued by the court on April 28th after the first complaint was filed. What we just read was the first amended complaint. But let's look at this court's minute order with an order to show cause. This is the judge setting its own order to show cause. This is the judge sitting down reading it. This is what happened. This is my dramatic reenactment of the federal judge. The federal judge sat down and read the complaint and went, seriously? WTF. Y'all get into court and show me how the fuck this all works together. I have questions. This is your order to show cause. The court has reviewed the complaint filed by plaintiff Triller Inc. against defendants, all of them. Plaintiff, except for H3H3 because they weren't sued yet. H3H3 didn't get sued till the first amendment complaint. Plaintiff alleges that it's the copyright owner and publisher of the broadcast of Jake Paul Ben Askren boxing event, and that defendants unlawfully uploaded, distributed, publicly displayed without authorization the broadcast to users of websites operated or affiliated with defendants. Complaint asserts the claims. Claims are listed. We just went through them. Federal Rule of Civil Procedure 20A2. Please note, the FRCP, there are rules, people. Society has rules, and the law has a fuck ton of them. Persons may be joined in one action as defendants if any right to relief is asserted against them jointly, severally, or in the alternative with respect to or arising out of the same transaction, occurrence, or series of transactions or occurrences, and any question of law or common fact to all defendants will arise from the action. Here's the thing. There is no fucking way that H3H3 is jointly, severally liable for what the fuck Mike did over on their channel. There's not a chance. There's not a chance. There's not a chance. There's not a chance. Not a chance. Okay, there is always a minute possibility. But I am just. And this is the thing we talked about for everybody who was here for the Toddy Westbrook lawsuit. We talked about this because the defendant in that suit, in the motion to dismiss, said, look, you should have joined necessary parties in that suit. You should have joined Jeffree Star and Shane Dawson and all these people should have been joined in. And we talked about joinder then going, no, Your alleged acts of defamation have nothing the fuck to do with anything Jeffree Star or Shane Dawson has done. And that's the same argument here. Your one person's upload has nothing the fuck to do with somebody else's upload. So they can't be jointly and severably liable to each other. It's like, look, we all did the same thing, so we all have to pay. Each individual here is separate. So you can't just lump them all together in a lawsuit for the sake of what? Saving yourself some time? Federal Rule of Civil Procedure 20A emphasis added, the first prong of same transaction requirement refers to similarity in factual background of claim. They cited case law. The court was so annoyed, case law came out. Case law came out. Plaintiff alleges that it is, quote, this is the court saying, well, actually, plaintiff alleges that it is informed and believes and thereon alleges that the actions and omissions that serve as the basis for this complaint were undertaken jointly and with the consent, conspiracy, cooperation, and joint participation of all defendants. The complaint also alleges on information and belief that at all times mentioned herein, we talked about this, each defendant was the agent, joint venture, and or employee of each and every other defendant. And in doing the things alleged in this complaint, each defendant was acting within the course and scope of such agency, joint venture, and employment with the permission and consent of each other defendants. Other than those conclusory allegations, the complaint does not contain any well-pleaded facts that plausibly support even an inference the defendants acted jointly. Whoop, there it is. The court is like, what the fuck have you filed? The court is not, the federal court is not happy. And I am living for the court not even waiting. The court's not even waiting for an attorney to come in. The court's like, no, nope, the fuck out of here with this. Oh. And then they quote more case law. This is them telling the lawyers, by the way, read the law. So they say, while legal conclusions can provide the framework of a complaint, they must be supported by facts. They must be supported by factual allegations. When there are well-pleaded factual allegations, a court should assume their veracity and determine whether they plausibly give rise to an entitlement of relief. So that's what that means. We talked about this again. We talked about this in the motion to dismiss with regard to the Toddy Westbrook because there were facts. Now, whether those facts actually arise to defamation causing damages is going to go to the fact finder, but it was on this day, this said this, on this day, this said this, on this day, this said this. This is what happened. This doesn't say that. This says, bruh, they worked together and stuff. Like, we know they did. For reals. For reals. They totally conspired because they all did the same thing. That doesn't work. Instead, it appears that plaintiff has improperly joined its claims against multiple defendants, alleged infringers who have no apparent connection to one another and who each allegedly infringed plaintiff's intellectual property rights by making the broadcast available on separate websites controlled by each of the separate defendants. The complaint does not sufficiently allege, identify, or explain any plausible relationship between defendants. Yeet. Motion to yeet. Defendants, file your motion to yeet. Yeet. Because it's improper joinder. Motion to dismiss based on improper joinder. Goodbye. For these reasons, the court orders plaintiffs to show cause in writing no later than May 10th why one or more of the defendants should not be dropped from this case for improper joinder. Each claim arises potentially different issues and must be viewed separate and individual light by the court. In response to this order to show cause, plaintiff may, if it chooses, limit its claims to one of the defendants. You can yeet everybody but one, and then you can go sue each of them on your own. Plaintiff may then, if it so chooses, file separate actions against other defendants. This is literally the court going, hey, the way you file a lawsuit is that there's somebody who did something and you file it against them. But then there's someone else who did something different and you file it against them because each download and upload is separate. This lawsuit makes me angry. Plaintiffs may then, if it so chooses, this is the court teaching you how to do law. If it so chooses, file separate actions against each of the other defendants with new complaints and filing fees. Pay. Failure to adequately respond to this order to show cause may result without further warning in the dismissal of the complaint without prejudice. If you don't deal with this, I will dismiss it. It is so ordered. Do not fucketh with the court. There's a footnote. The complaint's allegations concerning the Central District as proper venue of this action and in support of the court's exercise of personal jurisdiction over defendants is similarly based on only legal conclusions rather than well-pleaded facts. We don't even think we've got jurisdiction, friends. We don't even think we have jurisdictions, but this issue is bigger and much more glaring. So then they respond. And I have not read this. This is my first take. This is my first take on the response because I have not had a chance to read this yet because I was washing my hair. Just kidding. I was dyeing my hair. So we're still in this lawsuit. I know we're an hour in. This champagne is waiting for me. I'm ready to drink it. Let's do this response quickly. This is the response. Statement of relevant facts. Plaintiff is the copyright owner. We get it. Triller has since learned that certain individuals and entities utilize various torrent and streaming websites. You've already said that. That lists all of them. On April 28th, the court issued an OSC. We know that. In the OSC, the court noted, we're 3 pages in and they're just restating what they've already said. That's not good. In the OSC, the court noted plaintiff alleges. Okay. This is just restating what the court just said. That's just restating what the court just said. In the OSC, the court wrote that it appears plaintiff has improperly joined the claims and that the complaint does not sufficiently allege or identify or explain. You're almost 4 pages in and you haven't stated a fact. Holy shit. Statement of relevant facts. They're businesses. We're a business. The court said some stuff. I'm going to restate the rule. There's still the United States Supreme Court has explained under the rules, the impulse is toward entertaining the broadest possible scope of action consistent with fairness to the party. Joinder of claims, parties, and remedies is strongly encouraged. They still haven't stated a fact. They found a case that said joinder of claims and parties and remedies is encouraged, but they didn't say why. Defendants are properly joined in this action because, here's the facts. It's 3 lines long. Defendants are jointly and severably liable. No, they're not. Thriller's claims against defendants arise from the same transaction, occurrence, or series. No, they don't. There will be many questions of law and fact common to all defendants. That's not the standard. Defendants are jointly and severably liable. But it doesn't say how. Where is here defendant's liability is joint? No, there's no way that H3 is liable for Mike. There's no way. Triller's claims against defendant arise from the same transaction. The broadcast. No. The broadcast isn't the point. The uploads are the point. Not the broadcast isn't the illegal thing. It's each individual's own actions, either re-uploading it or live performing it. Why are you missing the point, plaintiff? That's not the thing. You're missing the point. As explained above, no, it wasn't. To satisfy the first prong of the permissive joinder test under Rule 20, the plaintiff may show that the claims asserted arise out of the same transaction. The defendant's action, not the original. The court's going to dismiss this case. As noted above, each of the causes of actions asserted by Triller arises from the same transaction or occurrence, the broadcast. I don't think that's going to fly. There will be questions of law and fact common to all defendants, but not all of them. Not every question or law or fact must be common, but the main fact is going to be how they uploaded it or rebroadcast it, and that's not going to be the same to everyone. Here, each cause of action asserted against each defendant arises from the very same set of operative facts. No, it doesn't. Whereas here, there are questions of law and fact common to all defendants. Joinder under Rule 20 is permitted. You've not added anything new. Okay, look. When the court issues a multiple-page minute order and cites case law, if you cannot bring something new, the correct response is, Your Honor, thank you for making me aware. My bad. We're going to go ahead and just leave plaintiff one or defendant one in. We're going to step away slowly and we'll just sue everybody else in their proper jurisdictions. Okay, thanks. Bye. So sorry. Here, each cause of action asserted against each event, it doesn't arise from the same facts. Triller can and will supplement its complaint. No. Oh, fuck no. Now's the time to do that. See, you were given till May 10th. You've still got a couple days. You were given till May 10th, and you went ahead and filed this on May 5th, 5 days early. The facts need to be supplemented the fuck now. Not that, nope. I'm going to pull this up in Pacer. Maybe it's already been dismissed. The court will probably wait till the 10th because they gave them that deadline and they could still file another reply, perhaps. Triller can and will. Well, if you can, do it now. Triller's eager to learn. You don't know. Right. You don't know. Is eager to learn and plead additional facts concerning the identities and relationships between defendants. This is why this case is going to get dismissed immediately, because they don't know the relationship between the defendants, but they've alleged a motherfucking conspiracy. Indeed, Triller is concurrently filing an ex parte application seeking leave to expedite discovery. You know what the court's going to say? No. Go sue them individually. What we're not going to do is pull them into expensive discovery because you don't know how they're related when you've alleged a conspiracy that we don't think exists. That's not going to fly. Triller anticipates using the information learned through its discovery to further support its claims. Nope. You have to have enough of it now to get over the joinder hurdle. Oh, no. At present, Triller is aware of certain facts demonstrating defendants' knowledge. This is the place to include them. They put them here. Facts go here. Don't say that you're aware of them. The court said, where are the facts? And what you've said is, well, we know them, but we're not going to show you. We know where the facts are hidden, Your Honor. But we're not going to show you. Yeah, no. Let's not play peekaboo with the federal judge, please. Oh my God. Emily, compose yourself. You're a professional. No, this is just ridiculous. Fuck it. At present, Triller is aware of certain facts demonstrating defendants' knowledge of other defendants' illegal uploading and distributing of broadcast. And? For example, while unlawfully redistributing the broadcast, certain defendants who informed their viewers who and fans of other defendants' unlawful redistributing of broadcast. That doesn't mean they're working together. Triller can immediately amend its pleadings to assert these allegations. But you didn't? So... For the foregoing reasons, this lawsuit's going to get dismissed immediately. Triller respectfully requests that the court permit Triller to obtain the discovery request and application. I can't imagine this court's going to grant discovery on this. The court's going to be like, oh, the fuck no. Out. Triller also anticipates using the information learned through its expedited discovery to further support its allegations that the Central District is proper venue. Yeah, what we're not going to do. What we're not going to do is issue expedited discovery to prove that there's jurisdiction. That's not going to, no, you need to go to state court and you need to sue each of these plaintiffs individually. I know you don't want to, but it's expensive to be you at this point. If you want to sue everybody who did this, it's expensive to be you. But bro, you've got $100 million lawsuit. So just, get that contingency cut and go for it. Oh my. You're not going to get expedited discovery to prove the basics of jurisdiction. Like, oh God, I am sorry, counsels, this isn't it for me. Attached is the proposed second amended complaint that literally adds nothing. And here's the second amended complaint again. We already went through that. So no, I imagine that what's going to happen, and I'm going to pull up Pacer real quick, because on May 10th, I'll be very interested to see what the court rules. I imagine that the court will not jump the gun on the date because it gave it till that date. I think we're going to see all but the first defendant getting dismissed out of this very quickly. So, if I'm the other defendants, I'm going to just sit and wait to see what happens in the court, because the court's already freaking salty about this. We're going to pop champagne in just a second. Let's pull up Pacer. And see if the court has said anything, because I literally I dyed my hair today. That's what we did today. We had other things to do today, people, and there was a lot of Duggar shit going on. This has been a busy legal week. There's a lot happening. All right, let's pull this docket and see. Has the court already, have you dismissed things? That would be so lovely. I stream on Tuesdays and Fridays, Your Honor. So I'm a big fan of your work. I love a sassy rebuttal. There are a few things that were filed May 6th. So let's see what this says. So, May 10th, let's see, May 10th is Monday. Yeah, if you could go ahead and dismiss it on Monday, I could talk about it on Tuesday. That would be very entertaining. I would be very amused. All right, let's go ahead and share this. Minute orders in chambers, reorder to show cause. Judge Percy Anderson, for all the foregoing reasons. Let's just pull this up. What did you do? What did you do? Oh shit. I did not expect to find this much. This is from May 6th. So what did the court do yesterday? Okay, hold on. We're popping champagne. We're just popping champagne now. The court has done things. I don't know what this is, but I don't want to wait any longer. I don't want to wait. So for everybody who's like, where's the concise breakdown of this lawsuit? There isn't one tonight. There is not a concise breakdown. I'll do a 1 minute short. There is not a concise breakdown of this shit. Look how sparkly. I can't wait to see what the court has done with this. Oh, this judge has been sassy already. I kind of love this lawsuit, but that was pages. That was pages. Do I love this more than Cuthbert? I don't know about that, but I'm loving this lawsuit. I'll tell you what. Okay, you came home in the car with me. I really like my desk. Can we be chill? Can we be chill? Look, we've got our pretty glass. We need to be chill. Let's be chill as we pop birthday bottles and then finish up this lawsuit and then get to questions, because good God in heaven, this lawsuit. I didn't think all of this would give me life so much. Paloma Rosa, sparkly. I like it's a sparkly rosé. And then, oh shit, that was loud. Yay, we didn't fuck it up. All right. That was loud. Pour it away from the camera. I am trying to not screw it up. All right. The question is, if we drink on stream, is it a business expense? These are props, people. Props. They're props. It's part of the mood. tears. Okay. Let's let's see what the court has done with this shit. I haven't even downloaded it. We're just going straight from Pacer. Actually, you know what? If I download it, I can pull it up bigger. So let's just do that and pull it up. It's going to pull up just as big. Hold on. Can we do that? No. Yes. No. How do I get rid of the sidebar? Oh, yay. Perfect. We just wanted it to be big. I like them big. I like them. Okay. Getting into this. The court ordered plaintiff to show cause why one or more of the defendants should not be dropped from this case for improper joinder. In issuing the order to show cause, the court noted that the complaint alleges that plaintiff is, quote, informed and believes and thereon alleges blah, blah, blah. We've read it 4 times. The complaint also alleges on information and belief that at all times mentioned herein, the court's now restating themselves. They're like, no, what the fuck I said was. What I said was. This is the court's version. This is the court's version of I said what I said. I said what I said. And what you brought back to me was not what I was asking for. The complaint also alleges on information and belief that at all times mentioned herein, each defendant was the agent, joint venture, and or employee of each and every other defendant, and in doing the things alleged in the complaint, each defendant was acting within the course and scope of agency, joint venture, etc. As the court explained, oof. Counsel, as I previously stated, words you don't want to hear from a judge. As the court explained in its order to show cause, other than these conclusory allegations, the complaint and the first amended complaint does not contain any well-pleaded facts that plausibly support even an inference that defendants acted jointly. Instead, it appears that plaintiff has improperly joined its claims against multiple different alleged infringers who have no apparent connections to one another and who each allegedly infringed plaintiff's intellectual property rights by making the broadcast available on the separate websites controlled by each of the separate defendants. The complaint does not specifically allege, identify, or explain any plausible relationship between all of the defendants. Plaintiff has filed a response and an ex parte application for expedited discovery. As part of its response, plaintiff requests leave to file a second amended complaint. Plaintiff's ex parte application seeks leave to serve subpoenas on third parties to assist plaintiff in uncovering the true identities and locations of defendants, which plaintiff claims it needs prior to filing a motion for permanent injunction. Plaintiff additionally contends that the expedited discovery would assist in responding to the court's order to show cause. And then it quotes that. It talks about the same transaction again. In addition to the legal conclusion alleged in the original complaint and the first amended complaint, the proposed second amended complaint adds the allegation that plaintiff is further informed and believes and thereon alleges that certain defendants were aware of and informed their subscribers, viewer, and fans of the existence of other defendants' illegal uploading and distribution of the broadcast, thereby demonstrating defendants' common enterprise. Yeah, no, it doesn't. Oh, also, do the YouTube things. Y'all, if you're not subscribed yet, could you do that and maybe like the video? Somebody let me know how many likes we're at, and maybe we'll bring in Pirate Emily with the purple hair. But do the YouTube things. There's almost 3,500 of y'all in here. Thank you. Nowhere in plaintiff's response does it provide examples of how one or more of the unspecified defendants informed viewers and other unspecified defendants' distribution of the broadcast. Here's the thing. Y'all remember in the Toddy Westbrook complaint against Without a Crystal Ball, when there were like quotes and links to articles and videos, those would be specific allegations. Those would be in this video, this said this. What we don't see here are facts. Instead, as it had previously. You didn't say anything new. Plaintiff relies on the barest legal conclusion to support the joinder of multiple separate entities without any well-pleaded factual allegations. We're going to drink every time the court said well-pleaded factual allegations. Supporting an inference of any joint action by defendants. In arguing that the broadcast itself, hey, the court's on the same page with me. High five. In arguing that the broadcast itself is the common transaction or occurrence supporting joinder, if you're gonna come in and interrupt Travis, you're gonna have to come on screen and do it.
Dad said we could come in here now. You don't want to scare me because I scared you way too many times to walk in your office.
You sometimes do scare me because I don't hear you coming. Because
Okay.
wait, the law nerds are gonna want to know what you think of the purple hair.
It's weird.
What did you just say? Say it into the microphone.
Yet again, the millionth time, it's weird.
It's weird that your mom has purple hair.
Yes.
It's fine. Are you excited by the subscriber number?
I mean, it'll take more than 6 weeks to come, so
It'll take more than 6 weeks to get the play button, so it's not exciting yet.
according to you.
Well, yeah, probably. Are you leaving?
I mean, I'll just stay right here.
I mean, I'm going to be streaming for a while longer.
I mean, Dad and Griffith are coming.
We're talking about the Jake Paul Ben Askren fight. Do you know who Jake Paul is?
Yes.
What are your thoughts about Jake Paul?
Yo, what's up? Hi. Sorry, I messed that up. I can't speak.
Those are your thoughts on Jake Paul? That's all we know about him?
What's popping, low gang?
That's it?
That's all I know.
That's what we got. Do you think he's annoying generally?
I mean, I've never seen him, so I wouldn't know.
Fair enough. Okay. I'm going to keep reading this lawsuit. This judge is getting very sassy.
Okay.
We like a sassy judge.
Okay.
Okay. Bye. Where were we? Joinder. We were at joinder of defendants. Joinder of defendants. Oh. And once we finish this and see what the court has ordered, then we are going to do a birthday cheers. But not yet. But not yet. But not yet. All right. In arguing that the broadcast itself is the common transaction or occurrence supporting joinder, plaintiff appears to have shifted the analysis solely to its copyrighted material rather than any common facts concerning defendant's alleged infringement. I mean, I said that in a much more basic way, but I said that too. Your Honor, I see you. Nothing in plaintiff's response provides any well-pleaded facts. We're drinking every time they say well-pleaded facts. Or other indication that defendants did anything other than operate independently of one another. Truth. By attempting to join defendants in a single action without any facts to support joint action, plaintiff increases the risk that the conduct of one defendant will be wrongly attributed to another defendant. Right. Mike's upload on his YouTube channel cannot be attributed to H3 just talking about it or showing a clip of it. Put simply, the court provided plaintiff when the court says put simply, what they mean is you dumb motherfucker. I'm dead. This is going to quickly become my favorite judicial sass ever. Put simply, the court provided plaintiff with an opportunity to provide the court with some evidentiary basis to support its conclusory allegations supporting joinder of defendants. Plaintiff's failure to provide any such evidence and ex parte application for expedited discovery indicates that it currently lacks facts to support joinder and calls into question the adequacy of plaintiff's compliance with, holy shit, with its pre-suit investigation obligations under Federal Rule of Civil Procedure 11. Not only am I going to call you an idiot, But I'm also going to say that you have improperly filed this lawsuit without doing the bare minimum research that is required to actually have reasonable support that your claim deserves evidence or has evidentiary proof. You are telling the court that you do not have a reasonable belief that your claim has evidentiary support. Sure, Jan. That's exactly what's happening here. Sure, Jan. The court additionally concludes that plaintiff has failed to establish good cause for the expedited discovery. To justify ex parte relief, the evidence must show that the moving party's cause will be irreparably prejudiced if the underlying motion is heard according to regular notice and procedures. Hi, G.
Guess what I'm wearing?
Why do you have a lifeguard hat on your head?
I want to wear it.
It's amazing. The law nerds are going to want to know, what do you think of the purple hair?
Cool.
You like it?
There's a movie on Disney. I can't say it.
There's a movie on Disney. Are you talking about The Descendants?
Yeah.
Yeah.
And you kind of look.
I kind of look like Mal. I'm going to take that. I love Mal. All right, I'm going to give this to you. We're still reading this lawsuit. The judge sass is just getting good. So, hey, the entire Baker clan is here.
You said you wanted us to come in.
I said you. No. I said you could come in and say hello.
Okay, we're coming in and saying hello. All right, do we need to move? All right, we're moving.
We're coming in and saying hi.
Well,
Hey, family.
Mom's giving us the boot.
I'm not giving you the boot. We're at the good part.
Oh.
I'm going to have to film a separate video to summarize this lawsuit without interruptions, but it's okay. That's what we're on a live stream for.
Post a poll on your community page asking about the purple hair.
Post a poll on the community page. Oh, the you're not on camera, so I'm not answering you. The community loves my hair.
Yeah, but that's only the couple thousand that's on the that's only the 3,000 on the stream, not the 100K.
Fine, I'll post a poll.
Come on, let's go.
I'll
Let's
post
go.
a poll.
Come on.
I'll see you. I'll
Come on,
post a
guys.
poll.
All right.
I'll post a poll. Love you.
Happy birthday.
Love you.
Let's go. Come on.
Bye.
Bye.
Birthday gift you on YouTube, but not mine.
Because mom's a real YouTuber now. We're just look. I will film a breakdown video of this case quickly, but this is the first look at the judge sass, and I'm dying to know what it says. I love you, family. I will be done streaming soon. We've been streaming for an hour and a half. This sass is getting really good. Okay. So the court's not going to order the ex parte relief is what we're reading. To justify ex parte relief, the evidence must show that the moving party's cause will be irreparably prejudiced if the underlying motion is heard according to the regular notice motion procedures. Kind of more like the Satan shoes. It's like, wait, but the shoes are going to go out. More like the Satan shoes. Additionally, it must establish that the moving party is without fault in creating the crisis. You did this to yourself. You done messed up, Aaron. You did this to yourself. That the moving party is without fault. Again, this would be like the Nike Satan shoes, where Nike is like, we didn't know they were coming out until somebody posted it on Twitter. Like, we're caught unaware. So in this, the judge is like, you created your own problem. In determining whether good cause justifies expedited discovery, courts commonly consider factors including whether a preliminary injunction is pending, the breadth of discovery, the purpose for requesting the discovery. The purpose of discovery is not to overstep the fact that you didn't do your due diligence. The burden on the defendants to comply with the request and how far in advance the typical discovery process request was made. Plaintiff asserts that it requires the third-party discovery to identify the defendants so that it may file an anticipated motion for preliminary injunction. According to plaintiff, a preliminary injunction is necessary to prevent the irreparable harm. Dude, the shit's out of the horse on this one. The broadcast already happened. According to plaintiff, a preliminary injunction is necessary to prevent irreparable harm of defendants continuing to offer the broadcast without authorization. Plaintiff does not, however, explain what irreparable harm it continues to suffer from the availability of copies of a live sporting event that occurred weeks ago. The SAS, the outcome of which is publicly available and lasted less than 2 minutes. The court thinks that the fight sucked. Your fight sucked, bro. How are you irreparably harmed? The stream happened weeks ago, and it was a live sporting event that lasted less than 2 minutes. Plaintiff therefore fails to establish the emergency necessary to support the consideration. As a result, there is no justification to allow plaintiffs to, quote, to go to the head of the line in front of all other litigants and receive special treatment. For all the foregoing reasons, the court denies plaintiff's ex parte application without prejudice to its being filed as a regularly noticed motion. The court additionally concludes that defendants are misjoined. Whoop. There it is. Because the proposed second amended complaint does not cure the misjoinder identified by the court denies plaintiff's request for leave to file the second amended complaint without prejudice to any efforts to seek amendment in a manner consistent with Federal Rule of Civil Procedure 15A. Pursuant to FRCP 21, misjoinder of parties is not grounds for dismissing an action. Instead, on motion or its own, the court may at any time on just terms add or drop a party. Where there is misjoinder, the court can generally dismiss all but the first named defendants without prejudice to the institution of new separate lawsuits against the dropped defendants. Accordingly, the court thus drops all defendants except filmdaily.com. This order does not limit plaintiff's ability to refile its claims against the remaining defendants in separate actions. It is so ordered. Therein, H3H3 is not being sued because the court has dropped them as a defendant. So at this moment, the only defendant in this lawsuit is Film Daily. What would the clickbait title say? What's the clickbait on this? H3H3 wins lawsuit. H3H3 no longer being sued. H3H3 not being sued. What's our clickbait title? Tell me. Because that lawsuit was almost as short as the fight. Like, let's be real. That lawsuit was almost as short as the fight was. Damn. You think the court, after writing that, was like, sure feels good to be a gangster. Jake Paul loses fight with H3H3. I like it. And that's the end of this lawsuit. I'm going to have to do a summary of this because it got so disjointed, but that's what happens on a live stream sometimes. Jake Paul loses fight with H3H3. I wonder if H3's lawyers have called them yet to let them know. Judge over H3H3 suit calls it stupid. I mean, basically. H3H3 not going to jail. H3H3 dropped. Clickbait title. Judge KO's Jake Paul's streaming lawsuit. Yes! Alicia, that's brilliant. Judge knocks out Triller. Oh, the court thinks this fight sucked. H3H3 wins. This was great. This is fantastic. Lawyer called Ethan at the end of the live stream. Oh, fantastic. I didn't watch the 3-hour live stream. I love it because this was just filed yesterday with the court. So yes, they absolutely could refile it separately. This was dismissed. We've all learned this was dismissed. No, it wasn't dismissed. It was dropped as to everybody but Film Daily without prejudice. That means they can refile it. So we're going to get into Q&A. I'm glad that H3H3 got their notice. What happened here? I'm glad that Ethan was called at the end of the stream. I'll go watch it. But yeah, that Ethan was sued for 7 seconds. Let's see. Ethan was sued. When was the second amended complaint filed? Let me pull it up real quick. Ethan was sued for like 6 days. That's hilarious. So the second amended complaint was April 29th. This was filed May 6th. Ethan Klein was sued for a week. Ethan's lawyer sent him a text at the end of the stream and said, call me. So I'd say Ethan knows now. Yeah, I'm sure he does, because this is the lawyer would be like, yeah, they're done. Can they countersue? I don't know if it would even be worth it, and if they even spent a lot of time or money with this yet. This was just at the beginning. So all Jake Paul did was create attention for H3H3. I don't know what they were thinking with this, but this was not well considered on behalf of the of Triller. I don't think Jake Paul was involved in this, like inextricably involved. I don't know who runs the company Triller, but I don't think Jake Paul was making those decisions. Maybe he was. Maybe that's the problem. But Mike is also getting dropped. So everybody's dropped. Everybody's dropped but Film Daily. Sorry, Film Daily, that you were named first. If they had gone in alphabetical order, it would have been Bill of Sport. But you got named first. So there you go. It lasted 2 minutes. That's what she said. Triller was suing, not Jake. This was Triller Fight Club that sued. Oh, man. All right, we're getting into Q&A because we're done with this. And, we need to do a cheers. We need to do a cheers in a minute. It was mentioned a few times this week that recording a trial hearing is illegal. How does that factor into the Zooms? Yeah, it's the Zooms and court videos available on YouTube. When the court makes them publicly available on YouTube, they can be re-streamed. When they are not public streams, when they are streams that the public has to apply for permission on, the court has different rules. There are some courts that are just live streaming court and making it publicly available to anyone who wants to essentially walk into the stream or pull up the stream. Some courts, especially federal courts, not state and local courts, will say you need permission to attend this court proceeding. We need to know who's attending the court proceeding. And it's open in that you can apply to be here, but it's not being streamed to the public. So those are being streamed with permission of the court. So it's different. Okay. We are here. Oh my goodness. We only have 1,300 left to hit our goal for the fundraiser. If you guys have come in midstream, we are doing a fundraiser for RAINN because it's a birthday stream, because we just hit 100K, because we've talked a lot about assaultive crimes. We are going to support a charity and the largest national charity that deals with the things that we've talked about. So we need to do a cheers with whatever you're drinking. I'm going to refill this a little bit. I will let them know that we're done talking because I didn't think that I would be covering that suit for an hour and a half. So, let's do a cheers. All right, law nerds near and far. Thank you for being here. Thank you for being a law nerd. It's a happy birthday to me. It's happy to spend it with you. We've got over 3,000 friends. We definitely couldn't have this many friends in person. One day, hopefully, we will get to do some of these streams live and in person and get to see each other and do questions from the audience and have a good old time. But until then, we're going to be doing this on the internet. I don't get to do what I do without you, and I appreciate you, and I love what we get to bring together here. So thank you. Cheers. Sarah, this will happen if Triller decides to sue Crackstream. How poetic that Jake knocks out Ben Askren in 2 minutes, but only lasts 2 minutes against H3. I mean, this wasn't even really against H3. He only lasted 2 minutes against the judge. The judge was not having any of it. And I got to be honest, I'm living for the sass out of the Central District of California. Like, the judge was like, what we're not going to do is waste my motherfucking time with this. So there's a quick rundown in how not to file a lawsuit. I need to look up and see who this judge is because we need to give a shout out. Assigned to Judge Percy Anderson. Well, Judge Anderson, well played. Why is that name familiar? Local judges become federal judges, which is why I just want to look and see if I know this judge because this name sounds familiar to me. Why is your picture not on the link? That makes it hard. I will be looking into this more because I'm like, this name sounds familiar to me. This name sounds familiar to me. I wonder if he ever worked in juvenile in Long Beach because looks like the same judge. We stand Percy Anderson. Where were you before? Percy Anderson has been appointed to the, here, we're going to pull up the judge's profile. Percy was appointed in May 1st, 2002. You were in AUSA in the Central District. I was not in the Central District. Nope. Not the judge I was thinking of, but we appreciate you, Percy Anderson. You go. Thank you for the sass. Was in Long Beach. Y'all, I'm telling you what. Oh, these are non-judicial positions. I wonder if he was the same judge that was in state court in Long Beach. Rated well qualified. Well, oh no, this actually he would have been appointed to the federal bench before I was in Long Beach. So boo. But that was fantastically sassy. There was no fucks given. The court was not having any of it. And I'm living for that. That's going to go at the top. That is my favorite. I love this. I love all of this. I love this so much. This has absolutely made my week. Thank you, Judge Anderson, for being a baller. And this lawsuit's going up there with favorites with Cuthbert because it's literally low key. And no, and it's sassy, and it ended quickly. It ended very quickly. Yikes. Question: do you have to sue them separately, or could you properly have them all in one lawsuit? And no. On this lawsuit, they have to be sued separately. Pink Piggy. We talked about joinder a little bit with regard to the Toddy Westbrook suit because the defense was like, you failed to join these parties. And we're like, that can't happen. You have to be doing the same thing together. It's like if there was an issue with a business and like 3 employees were involved, you could sue those 3 employees who did the thing. But you can't just say, okay, all these people illegally uploaded the video. Okay, well, each of those uploads is a separate cause of action. It's just expensive to do it that way, so they don't want to. But it's not a class action. Like, what is this? Question: did Brown write that suit? Nope. We saw the signing attorneys. The signing attorneys were from Novan and Novan in Los Angeles, California. I don't know who they are. The judge is absolutely a king. Judge is king. We love him. Hello, allegedly Angelo. Long time since I've been in one of your lives, so I missed the milestone. Congratulations. The color looks good. Thank you. It's good to see you. I've been seeing you around Twitter, keeping us all in the loop on the things. Wow. Any thoughts on Epic versus Apple? The secrecy in the game world, the game dev world seems wild. I have been focused on other things. I know they've started trials, so I will, because my kid wants me to explain it to him. So I will be jumping into that suit. Not at this moment, but yes, I will be covering it. No thoughts just yet. Oh, I'm going to try to get to some more questions. You guys can ask. I love answering your questions. That's literally what we're here for as creators, to provide information and be here. Law, I always say law is a conversation. Law is a conversation. It's best with questions. I love answering your questions, and I love being here with you guys. So please ask away, because we are now going to just talk about some stuff, and then we're going to get into court of public opinion. What are your thoughts on the Gabby Hanna stuff? I do not love the way that popped off on Twitter. I generally don't love a Twitter beef, even when I'm entertained. I don't love the way Gabby blamed literally all of the behavior on being ADHD, but I have known that I was ADHD since I was 16. And I have been able to work with that. I don't think it should be used as a defense mechanism, though sometimes my husband looks at me, he's like, Emily, really? And I'm like, I'm ADHD. I'm just reminding you, I'm doing my best. I did not realize that it's been 20 minutes. I thought it was only 5. My bad. But I also think that the fight over the misperception of a friendship is ridiculous, and I don't understand it. I also don't like the way she consistently misgendered Trish. I actually got a comment on an older video, and somebody's like, no, Trish's pronouns are they, them. I'm like, yes. Since Trish asked to use they, them pronouns, I have shifted, but the older videos do not use those pronouns because at that point, Trish had not asked to be they, them. So I thought that some of that was willful, and I didn't love it. I heard Daddy D'Amelio was on the board of Triller. Well, they can't be thrilled with these attorneys because they just got slapped upside the head by the court. Question: will consumers be sued? Technically, they can if they can find them, but it would be in small claims court. They would have to go after them for the $50. I mean, I don't think they could, because they're not re-uploading them. I don't think they could go after them for more than the cost of the fight. I could be wrong about that. So I don't know. Victoria, what do you think the real purposes of a filing like this? Well, if they had done it well, it would have been to notify others not to do this because they've got some other big fights coming up. Sorry, there's just a hair. It would have been to notify others not to do this when the next fight comes up. So that would have been the point. But they didn't do it very well. So others are going to be like, yeah, does it matter? Because I think H3 probably had one call with their attorneys and it's over for them right now. So we'll see. I think the strongest one is going to be on anybody that re-uploaded for simultaneous streaming so people could watch it on the re-upload and not watch it on pay-per-view. Anyone who shared it afterwards, it's going to be a much harder fight. Thank you, Smarsh. I am loving the purple hair. I FaceTimed my mom today and she's like, it's purple. I think she digs it. Hubby digs it. Travis is like, Mom, it's weird. I'm like, I get it. Was this worse than the Robin Hood case? Yes. Yes, it was. I love that the judge basically told the lawyer to do his job. Amy Norton, I love that too. The judge told the lawyer what to do and then came back and said, I said what I said and you still didn't do it. The fuck out of here with this. We love it. I did my gray hair today since you went purple. Congrats. Yay. Well, if you share it on social, be sure to tag me. Drinking cherry blossom and peach gin with Prosecco. I mean, that sounds amazing. Delish. I love what you guys are drinking. I am way, way behind on this. 1,000 left to go. Any donation is appreciated. Thank you. We are going to leave this open for a few days so replay crew can get in on it too. Hi, Mom. It's good to see you. Thank you for the birthday wishes. I'm going to call you after stream anyway, because we do that. Ooh, and of course, booze always makes my nose stuffy. So yay. Oh my goodness. 850 to go until 5,000. Thank you guys. Question: can you talk about the 30-day clemency Triller enacted? I saw a lot of 16-year-old kids on Reddit freaking out about it, and it feels unethical. I have got to look into what they offered. But again, you can't really sue 16-year-olds. So, that's going to border on giving advice. So Zammy Z, I cannot this evening. I don't want to appear to be giving legal advice, and I don't know how they are going to track everyone down, but it doesn't mean they won't spend the money to do it. Ashley's Pretty Little Life. Judge Percy says, happy birthday, Emily. Here is your gift. Isn't it a gift? It was a gift. Judge Percy, you are a gift. Thank you. Oh, I'm that far behind on the chat. Welcome as a member. We're not going to do that today. I will think on that and see if I can give an answer without giving advice. So I need to think on that. Isn't more likely judges, courts in California might have a lot more experience with copyright, maybe an obvious. I don't know if federal courts in California generally have more experience with copyright than somewhere like New York, where a lot of the big publishing houses are homed. So I don't know if they would necessarily have more to do. I mean, the US Copyright Office is going to have the most experience, but copyright in some of these particular charges are not super complicated. But when it comes to jurisdiction, it's not what court or judge might have the most experience with a thing. It's where it's appropriate to sue the parties. Hopefully that was helpful. So the last standing defendant stuck with $100 million lawsuit. I mean, Dawn, they're just making up numbers in this lawsuit at this point. They're going to have to prove what the person did and prove the damages as to that person. So they can call it $100 million all they want. They're going to have to prove it at trial. Thank you, Jamila. Question, where is the new purse? Ronnie G, that is a fantastic question. I am wearing her on my neck. I shared this on the members only live last night, and I'll share it on social media tomorrow. I ended up getting sidetracked and not getting a purse. I got a small diamond necklace instead, and a little bit of a wallet and a purse charm. Let's see if my purse is up here. Mom, avert your eyes. You're going to tell me that this is ridiculous. Oh, you'll see it when you're here in person anyway. But I also got my purse and I both got jewelry. So this is my favorite purse. I did not find a purse I loved more than this. So we got her a bag charm that says Vuitton in large puffy letters, and they are rainbow colored, and I love them. So, oh, and a wallet. Hold on. Is she in here? Yes, she is. I'm not going to show you the back. Oh, well, I'll show you the back a little, and a wallet. So we got some little things. This is the back. There's credit cards in there. And then there's a zipper for cash, and then my driver's license and stuff. I love it. So I didn't end up going with a purse. I ended up going with this. So this is the credit card that has the numbers off of it, and you can barely see. So I'm not too worried about it. Anyway, that is what we got instead of a purse, because at the end of the day, I love this purse the most. And carry it all the time. So this is really the big birthday present to me. From me, to me, all of the things. So thank you guys. Thank you. I love this. When I unboxed it on the members only stream last night, people were like, oh my God, it looks like a Triforce. I'm like, it does look like a Triforce, and I love it. What model is the purse? This Molly is about 4 or 5 years old and not sold anymore, but I can look it up. I have never seen it on a consignment site. I can look back in my my account and see what it's called. I don't know. I want her to hit the goal live. Octonation, ever so competitive. I adore you. Look, it binged tonight and everything. Did you pre-order the new iPad? I didn't pre-order the new iPad. You know why? Because I just got a new iPad and I love it, and I just couldn't justify it. And I couldn't justify all the things at once. So I just didn't need it. Yep. Yep, it was. Nick, if there's any question about how deeply, deeply nerdy I am, if you think it's some type of nerd reference, the answer is almost always going to be yes. Oh, I forgot to tell this story. Yes, there was a story time. We're doing a DA story time. All right. I alluded to this last night on the members only live stream and said I would share it with everybody because it's an instructive story time. And not a worry, Love Lamp. Thank you for recommending an alternative. I appreciate that. We're going to tell you all the things. There's only 3,200 of us here. I'm sure nobody will get this far in the replay anyway. It's totally fine. Let's tell stories. Cheers to a DA story time, friends. And then we're going to do court of public opinion. Sorry, mods. She's been drinking. We're going a little long. It's going to be great. DA story time. This came up in my mind because we were talking about the Chauvin case. I'm not going to get deeply into it, but there's the potential that the jurors will need to be interviewed, or at least one. And when that happens, they get called into court and questioned about something that might have been improper by the judge or by the attorneys, or both, depending on the circumstance, with everybody present except the other jurors. So I mentioned that there was a case where I had to do this with regard to juror impropriety. I had one trial with juror impropriety. It was a very, very awkward situation. And it ended up with the juror being removed. They had not started deliberating yet. And so the alternate juror ended up coming in as the juror. So, juror impropriety. Hello, Nick. It's good to see you. Guess what happened after you guys did a video on H3H3? They got removed from the lawsuit, so they're not getting sued anymore. It's good to see you guys. I feel like I can come hang out now because my hair fits in with you and Dustin, and I feel like we would just look like a box of Nerds candy. So thank you for coming in. Tell your hubby I said hi. It's good to see you. So sometimes you have to question jurors about juror impropriety. During a trial, jurors are not allowed to have interaction with the attorneys. You can't ask them questions. You're not even really supposed to hold the door for them as they exit the courtroom. They're not supposed to interact. It's like you don't exist in the same world. It's like la la la. And when the lawyers are in court, they look at the jurors and argue their case to them. Other than that, no interaction. No interaction. No interaction. So we come back from a lunch break, and the court had changed the rules about attorneys coming in through the judge's hallway. So the courthouse I was at the time had long, big hallways, and then offices on one side of the hallway and courtrooms on the other side of the hallway. And when you went into the courtroom, if you went out the back door, there was a long hallway that covered all of the courtrooms on that floor. And then behind that hallway were the jury rooms and bathrooms and an elevator for the judges. So the judges could come up from their parking garage without interacting with the public for safety, which totally right. And then they can come in through the back doors of their courtroom, and their chambers are back there too. But it's also to keep attorneys from mixing with jurors, because jurors use that back hallway to come back and forth from the courtroom. Though there were times when we would use the jury room bathrooms, when we didn't use the public restrooms, and then the judge in charge of that courthouse would you lawyers, stop running around in our hallways, please. And so we didn't use the back of the courtroom very much. So I'm waiting for the courtroom to open after lunch, because when you're in trial, you have to be on time, but you don't stay in the courtroom during lunch, and all the jurors are lining up there. And one of the jurors comes up to me and is like, hi. And I'm like, sir, you are a juror on my case and you can't talk to me. He's like, I have to tell you something. I'm like, sir, you are a juror in my case. I cannot talk to you. If you have an issue, you need to bring it up with the bailiff. He's like, no, I need to talk to you. I'm like, sir, I cannot talk to you. But also, I can't walk away because I have to go into court. And so I'm like, shit. And I'm just standing there going, damn it. And he's like, I have to tell you that I think you're an incredible woman. I'm like, sir, you cannot talk to me. If you need something, bring it up with the bailiff. He's like, I just think after this trial, and then he just starts going, I just think after this trial's over that maybe you and I should go out, blah, 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 and starts asking me out. Sir, I cannot talk to you. I am in the middle of a commercial burglary. Sir, this is a commercial burglary trial. What are you doing? And goes on and on. And I'm like, sir, I cannot talk to you. And the defense attorney's not there. And I'm like, the other jurors are there. And I'm like, you can't talk. And I keep just saying, sir, you cannot talk to me. You're on my jury. Sir, you cannot talk to me. You're on my jury. I think you're an incredible woman. I would just really like to ask you out. I think you're doing just a great job. And I'm like, oh my God, I can't talk to you. So the second the court opens, I tell the bailiff, I'm like, I need to speak to the judge. And the bailiff's like, what? I'm like, I need to speak to the judge. So the bailiff opens the courtroom and lets the attorneys in. The juror is still outside. The defense attorney comes to counsel table. And I look at the bailiff. I'm like, we need to talk to the court on the record before the jury comes back in. And the court's like, Miss Baker, what's this about? I'm like, juror number whatever spoke to me in the hallway and would not stop speaking to me in the hallway. And the court's like, do we need to put this in the record? I'm like, yep. And the defense attorney's like, wait, what? I was like, so the defense attorney's like, what's this about? And I'm like, he asked me out. And the defense attorney busts out laughing. And I'm like, go ahead. Laugh it up, furball. So the defense attorney's laughing hysterically because at this point, the defense attorney knows that now this isn't like, I saw, the defendant's mother saying that he's innocent. This wasn't like a case related thing, really. It wasn't the jurors being threatened. I've had that case too with that happening. It wasn't that. It was literally this juror doing something he shouldn't have done and needing to be removed. But the defense attorney thought it was fucking hilarious. And I was like, I was honestly mortified. And I'm like, at this point, I am not even 30 years old yet. So I am a young professional. This is the courthouse where I had been sexually harassed by a defense attorney. And so I'm just like, I am just trying to do my motherfucking job. And as a part of my job, what I need you to do, juror, is to sit the fuck down and listen to me as an attorney and let me do my job and stop trying to ask me out. Damn it. So then we had to bring the juror up and question him. And he's like, did you speak to the prosecutor? And the juror's like, yes, I did. And the judge is like, I gave you all these instructions that you couldn't talk to the attorneys. He's like, I just wanted to tell her that she is an incredible woman. And I'm like, and then he relayed to the court everything he said to me in the hallway. And the judge was like, okay, you broke the rules of the court. So we're going to have to excuse you from this trial. And I'm just sitting there like this. I'm like, I cannot. I was so annoyed. I was not even humored because I was in the middle of a trial. I was so annoyed. And then there was a part of me that was like, could you just sit there and just let me do my job? I was so annoyed. But he definitely tried it. He shot his shot while I was working. I was so annoyed. No, that's not how I met Dr. Badass. We met before I started law school. And we met before I started law school. But I do have colleagues that married people who had been on their juries later. I absolutely did have that happen. The chat has stopped listening to this story. I appreciate that. I have 2 other court stories. Did I win the case? No, I did not. That was one of very few that I did not win. You know why? Because it wasn't a commercial burglary, because the witnesses told the police one thing and then got on the stand and were like, well, it was kind of this other thing. I'm like, it was the right result. It was absolutely the right result. So it was. Somebody else said that is the best reason. I was trying to find the comment, is that was the best reason to turn down a date. I turned down other court dates for better reasons than that. So I just, I don't see where it was, but somebody said best reason to turn down a date ever. I had a better reason to turn down a date. Did I ever see the juror again? No. I was also married. I got hit on a lot in court when I was pregnant. That happened and it was weird, but I got hit on, unfortunately too much in court. But there was a case I did that I've talked about with a defense attorney, and the juror asked her out when we ended trial. It was my first felony trial. It was her first felony trial. She's amazing. I adore her, but I was married. I think she was either engaged or married at the time. And the foreperson of our jury, after they came back with a verdict, asked her out. And I had won. They hadn't even deliberated that long, so they weren't out that long. I won, and she was just like, he didn't even hang the jury and he wants to go out with me. I'm like, I won the jury and they thought you were super hot. It was a great case. Oh my God, you guys, we did it. We did it. Oh, you guys, we've raised $5,000 tonight for RAINN. That's incredible. That's incredible. You guys, that is absolutely incredible. That's the best birthday gift right there. Thank you. Thank you. Thank you. Law nerds. We did it. I wonder where we'll get to when the replay crew comes through. Thank you. Thank you. Thank you. Thank you. This generosity is absolutely, absolutely incredible. Yes, Ashley, to everyone who donated, to everyone who shared, and to everyone who watches, because ad revenue is going to go to it too. So thank you, thank you, thank you, thank you, thank you. I'm going to tell you, because we made it, I'm going to tell you one other story that I don't often tell, that is mortifying. So, you guys, this is incredible. Thank you. Thank you. Courtney, after everything we've talked about on this channel over the last few weeks, it felt like the only right option. So one more, the best reason to turn down a date in court. So I was walking to my courtroom, same courthouse, and a gentleman came out of a courtroom and was walking towards me and he was like, hey. And I was like, hey. And he's like, do you work here? And I was always hesitant to tell people that I was a DA because you never know how people feel about that particular profession. But I was like, yes, I work here because, again, I tried to be helpful in court if people needed to know where to go, because there's no need to be rude ever. So I was like, yes, I do work here. Can I help you? And he's like, I just had a question for you. I'm like, I can see if I can help. But then if they try to ask me about cases, I'm like, no. I'm a prosecutor. Don't ask me about things. I'm going to court. And he was like, I just wanted to say that I really think we could have something incredible. And I was like, thank you, but I'm married. So I appreciate that. I am flattered. I am married. He's like, I mean, there's kind of always room for something on the side. I'm like, no, but I appreciate that. That's not really how I roll. And he's like, well, if you weren't married, would you consider it? I'm like, sir, no, not at this time. And he's like, really? And I'm like, yes, really. He's like, well, why? And I'm like, well, you just walked out of the domestic violence courtroom. And so I maybe have a few concerns. And he's like, what? And I'm like, yeah, Department 8 only prosecutes domestic violence. So I'm assuming that you're either dealing with that or you're dealing with a case. And he's like, yeah, I'm dealing with a case. I'm like, So while I appreciate this, I feel like you probably need to resolve the other relationship that you're in. And maybe this isn't a right fit. And he's like, what? And I'm like, yeah. Also, I'm a prosecutor here, so I don't think that would really work out. And he was like, what? And I'm like, yeah, I don't think that's going to go well. He's like, oh, I see it. I was like, yeah, yep. Oh, and then there was another time where I had to disclose a relationship to the court. Oh, this. Oh, Jen Gerard, I heard you pushed us over our goal. Thank you so much. And thank you, mods, for letting me know. Okay, one more legal story. Should we do it as Lawyer Cat? Let's do it as Lawyer Cat. I've got one more embarrassing court story for you about Emily and the boys who apparently love her. Well, sometimes men, sometimes defendants, sometimes jurors. And when I come home with these things, my husband's always like, what happened? I was like, that's what happened. So is Lawyer Cat. Lawyer Cat would like to share this last story. So somebody was like, it's a courthouse, not Tinder. Oh no, Ashley. In fact, the amount, look, it's kind of like Grey's Anatomy, but with lawyers and cops. So there, when I was working in preliminary hearing court, we did a lot of cases every day. This was the judge who was not super patient with me when my cell phone rang and my very loud ringtone was Khalees. My milkshakes bring all the boys to the yard. And they're like, it's better. Yeah, in a dead ass silent court. Same judge. So we go through our witness list. Generally, if you are an attorney, you have to disclose if you have any knowledge or relationship with any witness or any other defense attorneys. Like if you're married to the defense attorney on a case, you're not going to be doing that case, right? You're going to be like, no, we can't have this case together. We're married. So I'm in prelim court. I'm checking in officers. This officer comes in with a fairly common last name. And I'm just checking in officers, looking literally, you can't see me because I'm lawyer cap, but I'm looking down at my little check-in paper. Then I'm like, hey, officer so-and-so, whose name I remember, but we're going to protect the innocent. We're going to protect the innocent and the identity of the innocent. So I'm looking down at my paper going, oh, so-and-so, blah, 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 blah. And then I look up and I was like, oh. And he's like, oh. I'm like, you're a cop? And he's like, are you the DA? Because it's a dude I dated in high school. I had no idea he had become an officer. He had no idea I had become a district attorney. And we were both like, oh, this is strange. So then I'm like, I probably should tell the judge that we actually know each other, even though it's been a really long time, because I just don't want it to ever be a problem with this particular judge. And he's like, no, I totally understand. You're a DA? I'm like, right, you're a cop. This is very confusing to me. Like, what has been going on in your life? Like, what is happening? And of course, at this point, it has been very many years since high school and, married. So I asked the defense attorney to go up to the bench with me. And I'm like, Your Honor, I just want to let you know the officer on this case, we know each other from high school. And the judge is like, oh, really? High school friends? I'm like, yes, Your Honor. Mind you, I'm in this court with this judge every single day for like 6 hours a day, all the time. So how do you know each other from high school? I'm like, well, Your Honor, we dated. Oh, really? How long did you date from Miss Baker? I'm like, Your Honor, we have not had contact since like my freshman or sophomore year in college when he played in like the Grammy Honor Band. And we maybe conversed then, but I did not know he had become an officer. He does not know I had become a DA. We do not have a personal friendship. We dated in high school. The judge is like, you dated in high school. And then starts laughing at me. I was like, why is everyone laughing at me? So yes, dated in high school. And the judge was like, thank you, Miss Baker. I appreciate your candor with the court. And the defense attorney was also giggling. It's like, I appreciate it. And I was like, I appreciate it. Thank you. And the defense attorney was like, so you guys haven't talked since like high school? I'm like, no, I'm married. I have been married for a long time. Yep. Those are some of the most embarrassing court moments. And they all ended up with people laughing at me. So there's that. Cheers to my own embarrassment. Things happen when you work in criminal courts. And when I say it's like Grey's Anatomy, but court, it's because it's like Grey's Anatomy, but court. All right, what we need to do is court of public opinion, and then we have to go because it's 9:20 and my sister-in-law is calling me because I have not gotten to talk to my sister-in-law and brother-in-law today since I dyed my hair, my sister-in-law and brother, and I need to say goodnight to my kiddos. So, and the mods have ridden all week. They're tired. I am sure they are great, but I am sure they are tired. So let's get into court of public opinion. It's the final countdown. Da-da-da, da-da-da-da, da-da-da-da. Ba-da-ba-ba-ba. Yes, it's the final countdown. We are in the finals. For everyone who's new here that found us this week, welcome. We normally do Court of Public Opinion on Friday. And on Friday, when we do Court of Public Opinion, we normally do one-off topics. We have lots of them. They're a lot of fun. We timestamp them if you want to see past ones. And then we normally rule on them on Tuesday. But we have been doing the April apology bracket. It's appropriate that we are just finishing it in the last week of May. But y'all, with over 6,000 votes on YouTube, in the April apology bracket, we came down to the finals of worst YouTuber apology between Shane Dawson and James Charles. And look at this. James Charles was 66% worst YouTube apology here on YouTube. If you want to go see the comments, they're all up on my community tab. Let's see what Twitter said. James Charles was 68%. It always blows my mind that the spreads are just about the same because I know it's not the same people voting, but it's generally the same. So with 1,200 votes, 31% to 66%. These are the top two worst from our poll. And as I've got all of my DMs up. Sorry, y'all. Nothing untoward there. So that's what we're at. We are at all of this. James Charles is now officially the worst. Wait, that was Mike. We don't know. Nope, this one. James Charles with over 66% of the vote. James Charles has been deemed by the Court of Public Opinion with the power vested in me through the YouTube things to be the worst YouTuber apology. It is so ruled. This is the way. I will update the bracket and I will post it for everyone. Let me know in the chat with a 1 if you had James Charles as the worst apology. Let me know. Thank you for everyone who DM'd me on Twitter telling me I was on mute earlier in the stream. We'll timestamp that part. A lot of you had James Charles as the worst. So this is what it is. I still say Laura Lee, and that's KK. You can disagree with the Court of Public Opinion. It is absolutely fine. I will be careful. I mean, there has been alcohol. 1-1-1-1-1. I had James going to the finals too. Do you guys want to see my bracket? I'll show you my bracket. My bracket didn't come down the way everyone else's did. I didn't share it because I didn't want to influence the vote. So I did my bracket ages ago. And let me share my bracket with you. I've got to download it real quick. So I still had James winning, but I got there a different way than everybody else did. And it took work, honey. The bracket took effort. There were some that were really hard for me. So let me see if I can pull this up into the chat. I've got to do a thing. We've got to do a thing and put it in a place. All right. Let's do a thing so I can show you my bracket. We need to put it here. All right. Let's upload it. So I'm going to show you both brackets. I'm going to show you the one that came down, and then I'm going to show you mine, and then we're going to go. All right. April apology bracket. This is the Law Nerd official bracket. This had all the breakdowns. So when we got to the final four, it was Shane, Olivia, James, Dobrik, Shane, James. James has now won. I will move him into the circle of dishonor, and that will be the end of it. Let me show you my bracket and how I broke these down, because I did not sweep on this. I had Tana beating Shane. I had Laura beating Olivia. And James and Dobrik were the same. So I came down to Laura versus James with James winning. So I got there a little bit different. I don't like it, but by the time we got to the final four, I don't like all of these, and I don't like Shane's. I do think Tana's was worse than Shane's. But Shane's was, I think, maybe more manipulative. Tana's was pretty out front. Tana's was pretty terribly in your face, like, I don't want to have to apologize, but I'm apologizing. And that offended me. But I think Shane's was more manipulative. So I had a hard time. I had a hard time with it. Amy Yost was like, we're on the same page. A lot of you agreed with Tana. So that's what it was. Cherie, this is a fantastic suggestion. Well, maybe next April we'll have to do it again. We'll have to do another April apology bracket. Let's maybe hope that we can't do it again because there's not enough apologies. Let's hope that YouTube does better and there aren't that many apologies. But I love that idea of doing an April apology bracket every year for the Court of Public Opinion. And then next week, we'll get back to regular Courts of Public Opinion. Why wasn't Gabby Hanna's included? Because she got bounced out at the beginning. Don't worry, we can do historical ones. She can be included in the next one. But the Law Nerds did not pick her. These are the ones that we thought were the most relevant when the Law Nerds kind of voted on who was getting in here. So that's what it was. We met our goal. Also, if you're on stream, it will show you. Here, let me show you real quick. Let me go onto my channel and try not to make it loud because I don't want to pull up my own stream while I'm pulling up my stream. But underneath the chat, here, let me show it. So you're going to see the chat. Underneath the chat, it will say, why isn't that? Everything has frozen. It's gone into like Inception at this point. So underneath the chat, it will show how much is raised. And we have raised, where are we? We have raised $5,325 out of 5,000. So we met our goal, we smashed it, and there's still room for the replay crew. So that's what it was. That's what it was. There we go. And this will go directly from YouTube to RAINN. So you can only pick, if you run a giveaway through or a charity, if you run a giving event, that's what I was like trying to do that. If you run a giving event through YouTube, YouTube donates it directly. So the charity has to be registered with Google, and then they don't take 30%. They just forward it right to the charity, which I really like because A, then I don't have to manage it and deal with the 30% and send it. B, it goes right from YouTube. And C, YouTube does not take a cut. And that I absolutely love. So all the information under there, if you go to show more, it gives you more about RAINN. It gives you all their information. And then I've got a link in the chat. So they are a sexual violence charity. They are the largest one in the US. And they are a very, very well-rated charity. And that's why we picked them. So yay! 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 Oh, you guys, it has been such a great stream. Amy, I appreciate the heads up. I've got to be totally honest. I don't care. I always appreciate the heads up, but also, I mean, it's a Thursday, it's a Friday, it's a whatever. We're doing a charity stream. We've got our things going on. I don't really pay attention to creators that I don't watch. And creators whose content I don't find to be helpful, I do not engage with. I engage with the people that uplift and do not engage with others. So I appreciate it, but it just is. It is. If it gets to the point where it's horrible and defamatory, and there are moments, I know that people will let me know and I will deal with it. So thank you. We're too busy dyeing our hair. And sometimes we're busy washing our hair. And sometimes we're just busy reading lawsuits so we can give good content here and answer y'all's questions because I like hanging out with the law nerds. So again, no shade. I appreciate the heads up. I just wanted to let you know that it is not, don't feel obligated to give the heads up because we just don't care. We just don't. We're at 106,000 subs. It's just we've raised $5,300 for charity in this stream. Y'all. And we dismissed the lawsuit against H3H3. We've done so much. We've done so much good in the world. We've put the H3 lawsuit to bed. We've enjoyed a sassy judge. We've dyed our hair purple. We've breached 100,000 this week, and we've raised $5,000 for charity. Law nerds, you are the fucking best, and I love you all for being here. What we do here is amazing. What we do here is changing the conversation on the internet and bringing it back to facts. We are now hardcore stans of Judge Anderson on this channel. Judge Anderson. I'm going to start watching Judge Anderson's docket. I want to see what else Judge Anderson is ruling on. We're going to find some other Judge Anderson cases. Hope you agree with just standing Judge Anderson forever, because that response was pure joy. It was pure joy. It was legal joy this evening. And I'm going to see what else he's doing. I need to see what else he's doing. So yes, we've been busy this week. We've birthdayed. We've shopped at Vuitton. We've done all the things. And we've done some good for the world. You guys are the best. Cheers to another amazing year. Cheers to the Law Nerds continuing to elevate the conversation. Cheers, cheers, cheers to all of us. Yes, Judge Percy is GOAT. We're gonna stalk his docket and see what other cases he has. And be like, let's see what Judge Anderson has going on. We're here to do good, and that's what we're going to concern ourselves with. To all the moms in the chat, have a lovely Mother's Day. I will not be on social media much this weekend. I will be spending it with my family. I will be on a little to share the hair and stuff, but I will not be on social much. Thank you. It's been an hour and a half. Mods, thank you. What an incredible night, you guys. We binged, we purpled. I'm going to wrap up 1,000 times. We're just going to go. Thank you, thank you, thank you. I can't believe how much money we raised. When we wrap the charity, I will let you all know how much we've raised. I'm really and truly blown away by your generosity. And as the Law Nerds grow, we're going to be able to continue to do more good. And that is really incredible and powerful to me, because look at what we've all done together. More than a lot of us can do separately. And I haven't even matched my part yet. So I will let you know how much our ultimate donation is, because I will be matching in some of this. And once we get to the total, YouTube will send it away, and we'll get to celebrate that we've really done some good on this channel. And I'm blown away. Thank you. Thank you. Thank you. Thank you. Have a great night. Have a great weekend. I will be back here live on Tuesday. If you want to follow me on social, I'm at the Emily D. Baker. Thank you for being a Law Nerd. We will talk soon. Cheers. Oh, do the YouTube things on your way out. Let's make it bing again. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, LawNerdsUnite.com. Happy to have you. Support what we do here on the YouTube.